Hello friends, welcome to Insightsias initiative, another video in our prelims high yielding series. In last two videos we discussed about rapid revision related to fundamental rights which covered over the span of last 1 year. In today's video we are going to cover important current issues related to Parliament which covered over the period of last 1 year, and of course you know that the weightage of the topic related to Parliament is very much significant in the prelims exam. So don't miss out all these 5 topics, and if you have any doubts regarding these topics feel free to comment. Okay, so let's see the topics we are going to discuss in today's video. These 5 topics we are going to discuss: immunity of the legislators from bribery charges, cross voting, suspension of MPs, floor test, ethics committee. Okay, these 5 topics more or less they are much in news for the last 1 year, especially regarding the Indian Parliament. Okay. Of course, there are some other incidents are there like security breach of Parliament that don't exactly covers into the core topic of the Parliament. That is the reason I'm not including here. I'll include that in the miscellaneous topics of the Parliament. Okay. Once this series of videos are done, then we will move on to the next subject like SNT, environment, like so on and so forth. And before the prelims exam, like few days before, we will try to solve the PYQs related to subject wise. Are we clear about this? Now let's see immunity of legislators from bribery charges. So this is the one. First, the context. In this case, the 7-judge bench led by the Chief Justice of India, D.V. Chandrachud, said that bribery is not protected by the parliamentary privilege. You all know that Article 105 comes under covers the parliamentary privilege. Regarding the assembly, it is the Article 194. Parliamentary privileges are given with a very bona fide intention. It gives protection to the freedom of speech of the parliamentarian so that parliamentarians can function without any hindrance. So these privileges will improve for the betterment of the parliamentary system, but these parliamentary privileges, they cannot be misused. What happened during the time of P.V. Narasimha Rao case? In that particular case, Supreme Court mentioned that even though parliamentarians taking the bribes, if the bribe is related to the action of the parliament, that covers under the parliamentary privilege. That means even though a person taking the MP taking the bribe and voted, because that voting is related to parliament, that bribery also comes under the protected by the parliamentary privilege, so they cannot be prosecuted. That was a judgment previously given by the Supreme Court. Now that interpretation was reversed by this judgment. The judgment is saying that parliamentary privileges are given with a very bona fide intention. A person MP cannot be misused. Now tell me whether the parliamentary privileges are mentioned in the constitution or not. Comment your answer. Next, parliamentary privileges are the special rights and immunities and exemptions enjoyed by the 2 houses of the parliament and the legislators of the state. Parliamentary privileges are also enjoyed by the parliamentary committees and parliamentary committee members and whoever eligible to speak in the parliament. That is, Attorney General also will enjoy the parliamentary privilege. But here you have to remember one thing: parliamentary privileges are not applicable to President and Governor because they enjoy more privileges under Article 366. So they don't cover under Article 105. Next. So they are not applicable, and assembly we already covered. And parliamentary privileges. Parliamentary privileges includes both individual privileges as well as the collective privileges. Individual privileges means privileges applicable to individual MPs. That means MPs have all the freedom of speech and expression within the house, and they cannot be arrested in any civil case before 40 days and after 40 days after the session. They cannot be called for any witness in any court during the parliament session is going on. And if they are arrested, the house has all the right to know about their arrest. This is about generally the individual rights of the parliamentarian. The collective rights of the houses are generally, so house can have all the right to make their own rules. They can conduct the secret sitting, and they can prohibit any publication house from publishing the house proceedings. But if the proceeding is related to public importance, then that can be published according to the 44th Constitution Amendment Act 1978. And any arrest within the precinct of the parliament, before that arrest, presiding officer previous approval has to be taken. So these are the collective privileges of the parliament. Okay, and of course parliamentary privileges. Under parliamentary privileges, right to freedom of speech to parliamentarian, that is different from Article 19 Clause 1A, because Article 19 Clause 1A is applicable only to the citizens. Okay, I mean applicable to every citizen, I mean to say, not related to parliament. But this particular article 105 only related to the parliament. In the PV Narasimha Rao case, Supreme Court mentioned that even though the parliamentarians are taking the bribe, they will be protected under the parliamentary privileges. Now the Supreme Court took the different view in this particular case. The second topic is about the Rajya Sabha election. Recently, various instances we have seen that cross voting happened in the Rajya Sabha elections. So before you know everything, you have to understand that in India Parliament, we are following the bicameral legislation, that is Lok Sabha and Rajya Sabha. If you remember, tell me, for the first time when we introduced the bicameral legislature, I mean in the colonial times, in the British India, for the first time when we introduced the bicameral legislation. Now the point is here, in Rajya Sabha, Lok Sabha, there is a bicameral legislature. Lok Sabha members are directly elected by the people, whereas Rajya Sabha members are elected by the MLAs. Okay, while MLAs are electing the Rajya Sabha MPs, they have to show their vote preference to their party agent. That means Rajya Sabha election is nothing but the open ballot. Of course, Supreme Court also supported this open ballot system in the Kuldeep Nair case. So, when the open ballot system is there, that means when MLA is voting, they have to vote to the candidate which is supported by the party. Okay. So, how the party will know? Before the MLA is voting in the Rajya Sabha election, they have to show their vote preference to the party agent. In case if the MLA is not obeying the party orders, here the crucial thing you have to understand that party cannot issue the whip. Normally, according to Schedule 10, party whips are applicable only to the lower house. Party cannot issue the whip regarding the Rajya Sabha election, regarding the Rajya Sabha elections. So party cannot issue the whip. They are clarified by the Election Commission of India also. So then what happens? In case an MLA is involved in the cross voting, what is the remedy? The remedy is party can suspend, but they don't be disqualified. That you have to understand here. So the recent Rajya Sabha elections in Uttar Pradesh, Himachal Pradesh and Karnataka have been witnessed instances of cross voting. Article 80, representatives of the Rajya Sabha, they will elected indirectly by the elected members of the Legislative Assembly. Elected members, that means previously whoever the Anglo-Indians used to be there in the assemblies, they won't involve. Next, the 1998 Rajya Sabha election in Maharashtra witnessed this kind of cross voting. By considering this, certain amendments done to the Representation of People Act 1951. That amended section was section 59 was amended. According to that, open ballot system was introduced. The MLAs of the political parties, they are required to show their ballot paper to the authorized agent of the political party. And the Election Commission clarified that provisions of the 10th schedule regarding voting against the instruction of the party, it will not be applicable in the Rajya Sabha election. And that means effectively political parties cannot issue whip regarding the Rajya Sabha elections. The same thing supported by the Kuldeep Nair versus Union of India case Supreme Court. Supreme Court upheld that nothing wrong in having the open ballot system. Because if there is not open ballot system, if the party MLAs are not obeying the political party orders, then obviously the political party system will be collapsed. That is obviously affect the democratic system. Next, topic number 3. This is regarding the suspension of MPs. In the recent times, we have seen that the productivity of the parliament is decreasing and the anarchism in the parliament is increasing and the suspension rate of the MPs is also increasing. So regarding this, we will discuss about various suspension powers of the presiding officers of both Lok Sabha and Rajya Sabha. Here we will discuss about some rules related to Rajya Sabha presiding officer and Lok Sabha presiding officer. In the recent times, around how many MPs? Around 92 and more than 100 MPs, I think so. Around more than 100 MPs, they were suspended, and this is the highest toll after 1989 during the Rajiv Gandhi government time. So presiding officer, Lok Sabha presiding officer is known as Speaker, Deputy Speaker and panel of chairpersons. Rajya Sabha presiding officers are known as Chairman, Deputy Chairman and panel of chairpersons. And I'll ask you one question to you. If there is a vacancy in Lok Sabha Speaker and Lok Sabha Deputy Speaker, who will preside the House? Okay, comment your answer. And these presiding officer, they will maintain the order of the House so that House can function smoothly. In order to ensure that proceedings are conducted in the proper manner, Speaker or Chairman, they are empowered to force members to withdraw from the House if they violate any rules. Now, Rule 255, the general rules of procedures of Rajya Sabha, it is saying that Chairman may direct any member whose conduct is in the opinion grossly, disorderly, so the members can be asked to withdraw from the House. And any members so ordered, they will be withdrawn from the House for that particular day. Okay, and the next day they can attend. This is regarding the Rule 255 of the Rajya Sabha. Next, Rule 256. Under Rule 256, members can be suspended from the House. Under Rule 256, chairman can suspend the member even for the remainder of the session also. So that means compared to the Rule 255, Rule 256 punishment is somewhat harsher. You can call it as. In the same way, these kind of provisions are also there with respect to Lok Sabha also. Regarding the Lok Sabha, there are two rules, that is Rule 373 and the Rule 374, 374A. Rule 373, here Speaker will ask the member to withdraw from the House immediately, and generally this is applicable to the remainder of the day. Next, Rule 374, 374A. Generally these punishments are little bit harsher. The main difference between the Rule 374 and 374A are, under 374, the motion made, okay, the removal motion, I mean the member suspension motion, the motion will be introduced before the House and the House has to adopt the motion. Whereas 374A, member will be suspended without introducing any motion. So that is the main difference here between the 374 and 374A. Okay, next topic is, can courts involve in the suspension matters? Actually, according to Article 122, courts are not supposed to involve in the administrative activities of the House. But nonetheless, at certain times, if the suspension seems to be grossly violating the basic structure of the Constitution, courts can involve. That was happened regarding the Bombay Assembly. In the Maharashtra Assembly, when members suspended for more than 1 year, Bombay High Court involved, and even Supreme Court also supported the Bombay High Court decision. That is, members generally they can be suspended maximum for the 5 working days or the full session. More than that, they cannot be suspended. If they suspended more than that time, means the constituency problems, especially in the lower houses, the problems related to their constituencies, they cannot be raised in the House. So that is violation of the basic structure. Next, topic number 4. This is regarding the floor test. Recently, Jharkhand government, they faced the floor test after the arrest of the Hemant Soren. You know that Hemant Soren was arrested under various charges, of course, related to prevention of money laundering and some by ED and some other cases. Champai Soren, who was appointed in the place of the Hemant Soren, he faced the floor test and he won the floor test with 47 votes in the 81 member assembly. Generally, we have to understand floor test always conducted in the lower house of the legislative body. That means Lok Sabha in the parliament and assembly in the state level. Floor test will determine the majority of the government. We all know that government will continually existence as long as they have the majority in the lower house. And normally, when after the election, if no party gets the majority, when 2 or more parties form the post-poll alliance, as soon as they form government, they have to seek the vote of confidence by going for the floor test. That is one incident. The second incident is if there is a prima facie evidence that, like for example, coalition government formed. After that, coalition government, when one party withdrawn from the coalition government, when the governor or president feels that there is a prima facie evidence that government is not enjoying the majority, then they may call for the floor test. Okay. Whenever president or governor are calling for the floor test, it should not lead to the destabilizing of the government. Okay. Whenever there is a prima facie evidence, then only they should call. Just because there is some internal fight in the political party, they cannot call for the floor test. Okay. But exactly that is what happened in the Maharashtra case. And Supreme Court clearly mentioned that internal feud within the party, that is not related to the governor or president. Okay. So floor test, it is a term used to test the majority. Normally, in Article 75 Clause 3 in the Parliament, we all know that Council of Ministers are collectively responsible to the lower house. They'll continue as long as they are having the majority in the lower house. The same applicable in the state level also under Article 164 Clause 3. Okay, so government has to prove the majority in the floor test. Especially the coalition government, they will go for the vote of confidence. In case if there is absence of clear majority, then they'll form the coalition government. After that, they'll go for this floor test. Floor test is a constitutional mechanism under which the CM appointed by the government, they can be asked to prove their majority, especially when they did not get the clear mandate in the election, their party or their pre-poll alliance party. Failing the floor test obviously resulted to the CM resignation, and when the house is in session, generally the floor test will be called by the presiding officer of the house. Otherwise, president in the central level, governor in the state level. In the SR Bombay case, Supreme Court clearly given a guidelines regarding under which way floor test can be conducted. Actually, before the SR Bommai case was happened, in Karnataka, the floor test was conducted in the Raj Bhavan. Okay, in Supreme Court, in SR Bommai case, Supreme Court clarified that floor test can be conducted only in the lower house of the assembly. It cannot be done in the Raj Bhavan or Rashtrapati Bhavan. Next, Article 174 is clearly saying that governor can summon, dissolve or prorogue the state assembly, but this is only under the advice of the Council of Ministers. But if the Council of Ministers are not enjoying the majority, then governor may not follow the advice of the Council of Ministers. Regarding this, in the Nabam Rebia and Bamang Felix versus Deputy Speaker case, Supreme Court clarified that the power to summon the House is not solely vested in the governor. It should be exercised with the aid and advice of the Council of Ministers as long as they are enjoying the majority in the House, because governor is only the nominated one. And Shivraj Singh Chauhan and others versus Speaker, in this case, Supreme Court clarified that Speaker can call for the floor test if there is a prima facie evidence. But the only thing is, governor must understand that his calling for the trust vote itself cannot lead to the toppling of the government. Okay, but unfortunately, this was exactly happened in the case of Maharashtra government. Okay, next, the topic number 5. This is regarding the ethics committee. Lok Sabha Speaker Om Birla referred BJP MP Nishikant Dube's bribe for query complaint against Trinamool Congress MP Mahua Maitra to the ethics committee of the lower house. You all know that, students. Parliamentary committees. Parliamentary committees are not mentioned in the constitution. They formed according to the parliament rules book. And parliamentary committees are two types: standing committees and ad hoc committees. Standing committees are again various types of the standing committees. Departmental standing committees, there are 24 departmental standing committees, and finance committees like parliamentary committee on PSUs and the parliament estimates committee and the parliament public account committee. Apart from that, there are ethics committee, privilege committee, and the detailed classification. I'm not going into that, but here, as we are discussing about the ethics committee, just I would like to give some information regarding the parliamentary committees. And of course, there are some joint parliamentary committees are also there. That includes the representation from both the houses. Ethics committee of the parliament. Generally, it is constituted first time in Rajya Sabha in 1997 and Lok Sabha in the 2000. It enforces the code of conduct of the members of the parliament. In case if the members misconduct, it recommends appropriate action. Always remember, the suggestions of the parliamentary committees, it should always taken with a pinch of salt. That means it's always only recommendatory in nature. It is not binding on the house. The committee should not contain more than 15 members, the ethics committee. Generally, these ethics committees are nominated by the speaker and they hold for office for 1 year. In the Rajya Sabha, it will be the chairman. The committee will examine any complaint related to the unethical behavior related to the Lok Sabha. Remember, ethics committees are exclusively related to the parliamentarians only. But the privilege committees, which are somewhat related to the ethics committee, the privilege committee, they are not only related to the parliamentarians, they can relate to other than parliamentarians also who violating the parliamentary privilege. That is the fundamental difference you have to understand between the privilege committee and ethics committee. Okay. Next. So we already discussed about this. Ethics committee, after the investigation is done, they'll put their report before the house and the house will consider whether to adapt that report or not. And privilege committee and ethics committee differences we already discussed. Committees of the parliament. Generally, parliament committees are nominated by the speaker or chairman. Article 105 of the parliament, it deals with the privileges of the MP and it also deals with the privileges of the parliamentary committees. Article 118, it gives parliament authority to make their own rules which regulate the procedures in both the houses. Reports of the departmental related standard committees are also recommendatory in nature. They are not binding. In fact, any parliamentary committee, they are only recommendatory in nature. Next, yesterday's video question. Consider the following and choose the correct code. Regarding this, the answer is D. That is, President convenes the sessions of each house of the parliament, right? And he can prorogue, of course, he can dissolve the Rajya Sabha, no. And he can dissolve the Lok Sabha on the advice of Council of Ministers, yes. So the answer is 1, 2, 4. Correct statement is 1, 2, 4. Next, today's questions. Today's MCQ questions. Question number 1. Which of the following are true? The Constitution of India does not mention the parliamentary privileges specifically in any article. There may be contempt of house without committing a breach of privilege. Next question. Question number 2. Consider the following statement. The Rajya Sabha has no power either to reject or to amend money bill. The Rajya Sabha cannot vote on the demand for grant. The Rajya Sabha cannot discuss the annual financial statement. Next question is consider the following statement. Under the Constitution, the presiding officer of Lok Sabha has been empowered to suspend an MP from the House for disorderly conduct. Second statement, the termination of the suspension order of the respective MP can only be done by the Speaker of the Lok Sabha. Next question. In case of death of a sitting governor, who among the following will discharge the functions of the governor of that state? So these are today's questions. As we reach to the end of this video, in this video we mainly discussed about rapid revision of current issues related to Parliament over last 1 year. I hope this video is useful to you, and if you have any suggestions regarding the further videos, feel free to give your suggestions. Thanks for watching this video. Have a great day. Jai Hind.